Tomorrow, the judiciary is set to launch the new law year. Tomorrow, the judiciary is set to launch the new law year, an event expected to be attended by judges, judicial officials, lawyers, and various dignitaries. However, some members of the Uganda Law Society have urged all lawyers to boycott the event in protest against what they view as increased interference from the executive in the judiciary's affairs. This call for boycott comes in the wake of an injunction against a meeting convened by the Uganda Law Society members to address perceived threats to the judiciary's independence. Tonight on The Spot, we delve into the question, is the independence of the judiciary truly under threat? Joining us to discuss this and related matters, we have a lawyer advocating for the boycott and the spokesperson of the judiciary. James Eremye Mawanda, Public Relations Officer at the Judiciary, thank you so much for joining us.
You're most welcome. Thank you for hosting us.
And Jude Vyamukama, thank you so much for joining us and for honoring our invitation. Both of you, I say a warm welcome to you.
Thank you.
Thank you, Patrick.
It is rare to find the Uganda Law Society and the Judiciary in a kind of a collusion course. But here you are. You seem to be now in a collusion course. And for us who are not lawyers like you, we're wondering why. For members of the Law Society to call for a meeting and you issue an injunction to say, not at all, it won't happen, must they seek approval from you?
Thank you, Mr. Kumara. First of all, I bring greetings from the Judiciary to our viewers, and I want to wish them a happy new year. You have asked a very interesting question, that for them to have a meeting, must they seek for permission from us, the Judiciary? And for us, we are saying that the Law Society has its own structures and systems on how they work. What you need to understand is that we are talking about a matter which is in court, and that's sub judice. We cannot go into matters that are before the court.
Okay, we are going to discuss this thing without specifically looking into the question at hand.
But the court has already decided.
No, but yes, we need to agree.
Okay. Let me not focus on what was supposed to be tomorrow, but under normal circumstances, a law society, a professional body of lawyers, when they are meeting really, must they seek approval from the judiciary?
And I don't want to think that these people came to seek approval from the judiciary. The Law Society was taken to court by a party. The Law Society is a party to the case. The court, exercising its mandate, listened to both parties, and a decision was rendered. It's not coming to seek for permission. It is a matter brought by a party to a matter brought before the court of law, the court exercising its function, listening to both parties, rendering a decision.
That's a very professional and interesting answer you've just given. Sure. But very interesting one. But do you find a problem in members of the Law Society having a meeting?
As I said earlier,
I'm asking, do you, as the judiciary, before a member of their own even goes to court, do you, as the judiciary, have a problem by having members of the Law Society have an extraordinary meeting?
Let us first agree.
Is that problematic?
The Law Society has been having meetings. This is not the first meeting the Law Society has had. They have been having a series of meetings called by their memberships, amongst themselves, AGMs, etc. This time around, they have a meeting they have called, and amongst their membership, one comes before the court.
I want to take it away from,
and the court,
I want to take it away, Mr. Remia, from the concerns of a member of the Law Society, I think Mr. Brian Kirima, who came to you. And I'm asking you as the judiciary, do you have a problem with the Uganda Law Society hosting or holding an extraordinary meeting?
Just as I said, they have all their rights to hold their meetings. But when a person or any aggrieved person comes before the courts of law, Article 28 of the Constitution gives that person the right to be heard, just as the other respondent party should be heard. And this is what happened.
And you found the grounds were meriting for you to issue an injunction?
A court of law...
Did you find the grounds meriting for you to issue an injunction?
A court of law, listening and exercising its discretion, proceeded to make a decision. And that's a decision of the court.
Okay.
And as we speak, the decision of the court is being contested.
Okay, let me come to you, because
the matter sub judice.
Mr. Mawanda is making a very interesting assertion, a very interesting submission, because one of your own is seeking redress from court. He does not agree with your intentions and he goes to court. And that's a democratic right. In any democratic country, dispensation, people can go to court. Mr. Brian Kirema, a member of the Uganda Law Society, went to court. He says, you know what, he does not agree with what is going to go on. Court listened to you and to him, and they issued an injunction. Isn't that how courts should work?
I'm afraid no.
Really?
I know, you know, Patrick, by the time some of us members of the Uganda Law Society take the very extraordinary step of saying, let's boycott the beginning of the new law year, to send a message. Our grievance is much more than this idea that we can't have a meeting and there's an injunction. And that is just a tip of the fundamental problem that we see. Now, under the laws that govern us, by the way, Uganda Law Society is governed by an Act of Parliament. Okay? Section 16 of that Act of Parliament gives a right to individual members of Uganda Law Society to petition for conduct of extraordinary general meetings. All they are required to have is at least 15 supporting signatures. So typically what happens is that a member is, any member who is able to mobilize 15 signatures will cause an extraordinary general meeting. If the agenda is pointless, chances are a handful of people will attend the meeting. If the agenda has objectionable items, people will show up and object and say, well, you have called us to discuss a court case, we don't agree, let's go and appeal if you're not happy with the court decision. But now we have to look at what is extraordinary here. Some members petitioned the president and his council for an extraordinary general meeting to discuss what we consider to be threats against independence of the judiciary. And then one of our members rushes to court, and the court gives an injunction saying the Uganda Law Society...
You know, you're saying rushes to court.
Yes.
Was he not in his right? Doesn't he have a right to go to court?
Courts are open to everyone.
Yes, if it was
but you
open
see, one fundamental thing
yes.
about courts of law, why we call them courts of law, and why we address the judicial officers as His Worship, His Honor, and as Justice, so and so. Courts of law are also courts of justice. They are supposed to administer the law. A court of law may not like me, a judge may not like me, a judge may not like Uganda Law Society. But ultimately, the duty of the judge is to follow the law and administer the law. Now, in this particular context, I will not get so much into this particular decision for various reasons. But what we want to focus on is what is fundamentally illegal or unlawful about members of Uganda Law Society meeting to talk about threats to judicial independence. It can only be, for now, what we have.
But you see, that was challenged by one of your own. In his own right, seeking redress. And he had an objectionable reason to say, you know what, you should not hold this.
By the way, the reason given by that individual is that he was worried that some of the things that would be discussed would be unlawful. In other words, speculation. That member does not complain that maybe 15 signatures have not been raised, or there is no power to call for that meeting. The gist of the member's complaint and the case before the court.
Were you invited to defend your vision, your view of why you should have a meeting?
Now that's quite interesting.
Were you invited?
The members who were petitioning for that meeting, in fact, only get to learn that someone has gone to court on the day of hearing of this application. Because when Uganda Law Society is taken to court, the people who get to know about the case are our president and his counsel. Me as an individual, if I have petitioned for a meeting, I can't know.
Are you saying they never they didn't get to know in time? They were not given time. They were not given time to defend their view?
No, they were not given any time. But the individuals who are petitioning only get to wait. The individuals who are petitioning only get to learn that, oh, there is actually a member who has gone to court to block the meeting. And then the order of the court, quite interesting, is court to say an injunction is given against members' petitions. In other words, not for that particular meeting, but the order is court to suggest that no other member of Uganda Law Society with 15 signatures can petition for an extraordinary general meeting. And that's what's the problem we are looking at here. We simply have complaints.
We want to get into the complaints, but they have used a technical method to stop your injunction to go through, which is also a right way, because one of your own petitioned, and that's how the courts work, and that's how democracy works.
And that's the point. And that's why we are saying.
What you should be doing, you may disagree with the injunction, but you have to respect it as a lawyer.
Well, no meeting took place, and that was the purpose of the order.
Yeah.
That's why we are saying this is extraordinary, and therefore it calls for us to at least make a symbolic action to point out that, one, we are not happy that our members are being gagged, and they cannot discuss independence of the judiciary, and yet independence of the judiciary is the fulcrum of us who practice law. Okay. There is no point in having lawyers if you don't have an independent judiciary.
You know, he has used the word, the members are being gagged. And really, that's big. Being gagged by the judiciary itself. So, we have descended to this low level like this?
Kamara, I want to appreciate where my brother Jude is coming from. But I want to lay the position straight, okay? And I don't want us to miss the point. He is a lawyer, and I respect the Uganda Law Society and its membership. What I want to come out very clearly to my brother and his colleagues in the fraternity is that as a judiciary, we have never chosen to interfere with how they operate with their meetings, and they have called many of them, and we have never issued any arbitrary, or call it gagging orders. What comes out clear here is that one of their own, in their own pursuit for whatever they wanted to discuss, exercising his right to redress in a court of law, went to court. Court issued the legal process. He knows the due process of law and fair hearing. He has admitted that the Uganda Law Society was served, but he hastens to add, not them, the petitioners, but he admits that the Uganda Law Society was served. And so Uganda Law Society had an opportunity to contest the application, and that's what happened before the judge. And the judge did his noble duty. he listened to the parties and rendered a decision. And that's what I want everybody to appreciate, that yes, they may have issues, they may have very good objectives, okay? But when a matter now becomes a matter before a court, we should respect the due process of the law. As simple as that. And I also want to say this, that he knows, and the society knows, that where there is a dissatisfaction on a decision of a court, there are means you can appeal against those decisions. And I want to tell him, I don't know whether he's aware that the society has chosen to exercise that right of appeal. And that's why he said we should leave the matters in court because they are sub judice. We allow the courts to do their functions and respect that that's the rule of law. And that's what we are as members of the fraternity supposed to foster.
With that kind of submission, I think it appears we are under the rule of law. I mean, the law is taking its course. Yes. I find it convincing.
You know, Patrick,
how do you respond?
You see, Patrick, there are two things.
Yes.
There's what we call the rule of law, and then there's what we call the rule by law. You can have court orders, you can have decisions of court. It doesn't mean that every time you have a court decision, the decision is just, the decision is legitimate, and it's rational. A court of law can make a decision which a court of justice would not make. And we are looking at situations where, when we look at the ecosystem in which these matters are getting decided, fine, the Uganda Law Society can file an appeal. When will it be heard?
You know,
and you see, but you see the fundamental issue
but
is...
you see, he was already talking of speculation.
Yes.
But why are you speculating what is not there?
Because there is a track record. There's a track record of what happens, and I don't really want us to focus so much about this particular
we're about to leave
case. It's because we'll lose focus on the fundamental problem.
Because
that want to be addressed. For me, I think the fundamental question that we have to be able to answer is, what is wrong with a group of lawyers? What is wrong with a group of lawyers discussing what they perceive to be threats to the independence of the judiciary? Because you see,
in his submission, there's nothing wrong with that.
For us lawyers,
there's nothing wrong with that. But one of your own,
and one of their own,
exercising his right.
You see, Patrick,
the courts of law.
You know, Patrick, for us lawyers, our job is to represent people. Ultimately, the job that His Worship has, the job that the judges have, is quite different from ours. Ultimately, they have to render a decision. That decision must be in accordance with the law. That decision...
Your Worship, you know what you just said? You could be a court of law, but you may not be a court of justice.
Patrick.
I think that's what
Patrick, I want to respectfully respond to my brother Judy and tell him that the semantics he's bringing, okay, actually what the legal process even allows any party aggrieved of a decision of a court to exercise his rights. If the first court is a court of law, did you say a court of what?
I think if I had a court of law, but not a court of justice.
If the first court was a court of law, okay, and they were dissatisfied in his own semantics, that they were dissatisfied with that decision, the appellate process is available, okay, to go to the next level.
Okay.
Okay. And before we leave this point, is we cannot be here to say we are fighting for the independence of the judiciary, but we who are fighting do not appreciate that independence again. Because what's wrong with my brother Judy, okay, to appreciate that the judiciary are independent and they have exercised their role and mandate as by law established, and they rendered this decision. And if they are dissatisfied, then they would proceed to the next level of appeal, and also in this context also allow the court exercise a final and render a final decision in the matter before it.
Gentlemen, hold on to your points, gentlemen, because we're going to take a break here, and when we come back, I want to ask Jude, what is it that they want to address? Why do they really need this extraordinary meeting that they had called for? We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guests tonight are James Eremye Mawanda, Public Relations Officer of the Judiciary, and Jude Byamukama. No, Jude, you had called for this meeting. Extraordinary. Of course, now there was that injunction. But what is your headache as Uganda Law Society?
Now, as Uganda, of course, obviously, I'm not speaking on behalf of Uganda Law Society, but on behalf of aggrieved members, as lawyers.
As lawyers, what's your headache?
Our complaints are many. We see so many threats to the independence of the judiciary in this country. The threats are both within and without. In other words, we see some threats to the independence of individual judicial officers who cannot render decisions either because their superiors or their supervisors are forcing their hand. And then, of course, this is in the public domain already. We have that very scandalous letter, in our view, written by the president, literally directing the Chief Justice to get a file that's before a court, not even in the Supreme Court where he sits, but in the Court of Appeal, and personally review it. Now, when you get that's the letter written by the president to the Chief Justice on the 7th of December last year.
On the issue of the Muslim property, right?
Yes, there's a court case. The Uganda Muslim Supreme Council is a party. They are pursuing their rights, fair enough. And the president says he has been complained to, and now is more or less, well, he says requesting, but from what we see, I think it was more of a directive. The Chief Justice to get a file and review it. How does the Chief Justice accept such interference and not clarify and maybe respond to the Chief Justice and to ask the members of the public? Are we supposed to believe that any time I am representing a person before the courts of law and the president intervenes, then I might as well forget about it? We saw that as an extremely concerning development that required to be discussed, and that is just one. We have also had again last year. We had the registrar of the commercial court related more in a slightly different matter, issuing an order of attachment of money on a bank account, bringing it to Uganda Revenue Authority. And then the principal judge writes to the registrar directing her to recall her order immediately, and also directing the bank in question to ignore or defy the order which the registrar had made freezing a particular bank account.
Okay. So
those are just two parts.
The separation of powers. Mawanda, you clearly, I wonder what you make of this letter. But I've also heard your own minister, you know, who's also a lawyer, thinking maybe this letter was not, if I had him right, it was uncalled for. It shouldn't have been written to the Chief Justice from the executive.
I don't know your point of view and how you got to that
but anyway, this has been understood to mean interference with the judiciary at the highest order, at the highest level.
Yes, that is what my brother Judy is ascribing to it. And I want to say that the Honorable Chief Justice has been very clear on the issue of defending the independence of the judiciary, and he is completely committed to ensuring that as long as he is still in charge, he will continue to ensure that the independence of the judiciary is realized.
Let me ask you, was the letter we're talking about written, addressed to him? Did the president address to him this letter? Did he write to him?
That letter I only see.
Mr. Mawanda, did he write to him?
I only see a social media copy, and you know, in this digital era, anything can be possible. However, of course, you can still. I don't know where you got it. This is the letter which was written.
So you are telling us that the president did not, on the 7th of December, write the Chief Justice?
Mr. Kamara, you listen to my submission, okay? One, I want to tell my brother and the Law Society that the Honorable Chief Justice even today, he reiterated the same statement, that one, he will continue to relate with the other arms of government. Okay? But in so doing, he will ensure that he continues to defend the independence of the judiciary. Now, a letter as it is being alleged, I don't know how it now fetters down that resolve of the Honorable Chief Justice. I want to pose a synergy, and I want Mr. Judy to tell me if there is interference in this aspect. A fountain of honor writing to his brother, talking about something, that's between the fountain of honor and his brother. Okay? Today, I want to bring a more localized example. The judiciary, we have been grappling with issues of funding for operations. We communicate to the Parliament, the legislature, which appropriates funds. Must Parliament construe that as an interference with their independence because they are an independent arm of government? We are relaying our concerns in our view, which we believe affects our constituency. Similarly, if the Honorable Chief Justice communicated to His Excellency the President about issues to do with the recruitment of judicial officers, and he expresses his dissatisfaction on the numbers, and so is appealing to the executive to find a way of resolving a problem, must the executive say we are interfering with their work? His Lordship, the Chief Justice, said that he will continue relating, and I think it is the positive relationship that we are looking at, okay? And that positive relationship is within the Big Brother house. Today, the Honorable Speaker of Parliament reiterated and gave the same resolve that they are committed to ensuring that they work with the judiciary and ask even the judiciary if there are issues pertaining to the Parliament. The doors are open, so but they are not interfering. However, let me give you this last point, okay? That permitted, that was that. Our courts continued to address the issues that were in court. The Muslim Supreme Council went to court. They filed the applications were heard, and the court made a decision. The Honorable Chief Justice does not sit in those courts. Today, we have decisions that the courts rendered, and the result of the impasse that was developing is that interference. There was no interference. The processes under the law continue to be followed. And the parties and our brothers, the Law Society, and all the aggrieved particular persons should appreciate that we should allow the courts to do their work. Okay, it's unfortunate that it's the lawyers who are supposed to be even our partners who are complaining.
If the pressure is coming from all corners to the judiciary, and the Honorable Chief Justice is not yielding to that kind of pressure, and the tempo of justice is still standing because he's not yielding, then that's a man who should be applauded.
Well, Patrick, let's look at what happened, maybe in some little detail, to understand what the problem is.
Don't let it not be an imaginary problem.
This is what the Constitution says, okay? Article 128 of the Constitution, it says, in exercise of judicial power, courts shall be independent and shall not be subject to the control or direction of any person or authority. And then clause 2 of Article 128 says, no person or authority shall interfere with the courts or judicial officers in the exercise of their judicial functions. Okay? Exercise of judicial functions is very important. Courts are supposed to be independent. That does not mean that the judiciary cannot sit with whether with the speaker, they cannot sit with the speaker to discuss funding for the judiciary. That's not a judicial function, that's an administrative function. Now, when you look at what the president wrote, his letter was about a warrant of attachment and sale of immovable property. And he's very specific and candid, and he points out that he has learned that a judge had made a decision. Actually, he poses a question in his letter that what sane person, let alone a judge, can make such orders? How can a mosque or church be attached for debts carelessly entered into? I therefore request you to review this matter. That's a matter before the court. This is not an administrative issue. Review this matter and see how to restore sanity. This letter was dated on the 7th of December 2023. And it was written, I think, a few days after a justice of the Court of Appeal had dismissed an application filed by the Uganda Muslim Supreme Council seeking a stay of execution. 1 week later, on the 14th of December, a panel of 3 justices now makes a decision granting the prayer, staying the execution within a week. So
that can't be a coincidence.
We have to ask ourselves, yes, the Chief Justice, on the paper, the Chief Justice received the letter, maybe he didn't act on it, but somehow, miraculously, within 7 days, a panel of 3 justices unusually sits to consider only one matter and renders a decision which the president wants.
Was it not in their right? The 3 justices
again,
to sit?
Yes.
Was it to sit?
But let my brother Judy first of all tell us the nature of the application the single judge justice handled. If he is capable of telling us the nature of the decision in the single justice application was, then he should then be able to lead us to why the 3 justices later and entertained the matter and rendered a decision.
No, you see, Patrick, what we are talking about, it doesn't mean ordinarily when you apply for an order to stop sale of your property, for instance, because you have a pending appeal, you have lost maybe before a lower court, you are in the Court of Appeal. You'll go before a single judge. The single judge may agree and stop the process, or may refuse. When a single judge refuses, yes, then you now have a right to seek the intervention of 3 judges. The normal scheduling of the court, would almost never permit any court user to succeed in getting that done within a week.
No, it
never happens.
No, that's your imagination.
No,
with the vibrant case management,
it never happens.
Now we are having.
And I can task you to find out. You will not get a single case in the last 5 years where this has happened.
No. Judy should understand. He's speaking from the aggrieved point of view. And I want to respect his feelings.
And the aggrieved point of view is wrong?
Okay. No. And that's what I'm saying. That, you see, my brother Judy should appreciate that when you are before a court of law, you expect 2 things. You expect to win the matter or to lose the matter. Now, my brother here is mixing 2 issues. He's mixing the question of how expeditious we are handling matters with his grievance that a different decision changing the earlier one was rendered. No, and that doesn't make sense to me. For me, I want Mr. Judy here to understand one thing, okay? That these are legal processes that were rendered in the court system.
So, I want you to respond.
You see the problem.
He quoted the law that no one should interfere with the court, especially in the process of dispensing justice. And this looks like right in the middle in the process.
You see, the problem with my brother is imputing his imagination, he's imputing his imagination to the processes. The letter he's quoting, it's right here. It's not addressed to any justice in the Court of Appeal. Neither is it in the commercial division. This is a letter which was written, according to the words I see here, to the Chief Justice. Now, this is a matter for the Chief Justice.
He's questioning one of the judges, in fact, even the sanity.
Yes.
And he has also he has a right to express.
Under the Honorable Chief Justice.
So he has
a
right.
You see, Patrick, by the way, the problem is
Wait a minute. the letter here is telling us that the Fountain of Honor, in his opinion, is expressing his feelings to the other head of the institution, you understand? And that's permitted. But me, I'm saying that whilst that was going on, the Honorable Chief Justice, in his resolve, not only today, but even previously, for as long as still in charge, has maintained that he shall ensure that the judiciary is independent in the performance of its duties. Now, this is what my brother doesn't want to hear. Because for him, he thinks that if anyone says, you do ABCD, it means that it's a given. No, that's not the case. You understand? And I have tried to demonstrate that from the commercial court where these matters originated from, processes, legal processes available to parties were explored and the decisions were rendered. He's complaining of expeditious trials. Why does he talk of Article 128 and is forgetting Article 28 itself? Speedy, expeditious trials. Now, this was a matter of national importance, and so the judges in allocating and listing cases, they have so many factors to consider, and one of them is sensitivity of the case. Okay, the other factors would be the possible issues that might arise if a decision is not rendered in time.
He's talked about something called sensitivity of the case.
Yes.
Really, you know, somebody was suggesting attaching a national mosque. Imagine.
What is even not telling you us is that they had smuggled it in. These very lawyers.
Well, but within your hallowed grounds of justice, really, the president scored political points to talk about, to tell the world that a mosque is untouchable. Don't even talk about it. And the church, you can imagine, you issue an order that you can attach a palace.
No, you see, Patrick,
Kampala or Uganda would be on fire the next day.
No, you see, Patrick, let's not, again, when we go into the specifics, we may lose focus of the broader issue.
Because that was the motive.
When you look at that, yes.
That was the motive behind.
When you look at the specifics, no one says, for instance, that, you know, a mosque should be attached and sold, a place of worship should be attached and sold.
But this is the situation which was there.
But as he told you himself at the start, when the court renders a ruling, if we are not happy with it, what do? We appeal to the next court. We don't appeal to the president.
His Excellency.
And you know, and the biggest problem which we have is, the biggest problem you have with this sort of situation is, you have preferential treatment for court users. That is one of the consequences when the independence of the judiciary is undermined.
He's talking about the sensitivity of the matter.
That is the point. The sensitivity
of the matter. Patrick, do you appreciate that?
Didn't we have a whole church demolished? Where was the judiciary and the president then? How come we didn't get these letters written? We had the whole church demolished.
Listen, don't confuse our listeners.
Preferential treatment of court users.
If an incident happened, must it happen again?
No, but there shouldn't be preferential treatment of court users.
The previous action should be able to prepare us for eventualities in the future. You understand that? My brother here should appreciate one thing, okay? That the sensitivity of matters is a factor in ensuring how we run cause listing and disposing of matters. This was a very sensitive matter, and I want to applaud the justice.
Do you appreciate that suggesting? Do you appreciate that suggesting to attach a house of prayer, of worship like that at that level,
and moreover wrongly,
could also become a matter of national security?
Of course, it can. It can, and that is why we want our judges and our judicial officers generally to be able to decide matters in accordance with the law and tenets of justice. That's why we want that to happen. But you see, that's not going to happen in a climate where their independence is undermined through blackmail, through threats. You'll get more erroneous decisions than right ones when our judicial officers focus on either pleasing the public or pleasing the powers that be. Okay. And we are complaining and saying, no, we do not want to see preferential treatment. What happened in this particular case, the outcome is something which all of us may be relieved. No one wanted to see a situation where you see that a mosque is being attacked.
Oh, I'm very happy. I'm very happy. My brother,
but what we know, what we know for sure is
the decision of the Court of Appeal was proper.
What the problem is, like I've said, let's not focus on the trees and forget the forest. If this happens, don't forget that this is a pattern of incidents. We had the president before complaining about judges granting bail after 2 members of parliament had been given bail by a high court judge in Masaka. And then the 2 MPs eventually get charged afresh, and this time a judge denies them bail. And they stay in prison for almost, was it over, I think, 1.5 years. And they get bail after a long struggle. And you clearly see that the statements of the president complaining about judges granting bail clearly had an effect on why these 2 gentlemen did not get denied bail. And that's the environment.
But you know, Mr. Mawanda, your worship, when I listen to Jude, I actually see a strategic partner to you, and you're trying to safeguard the independence of the judiciary. This is your strategic ally. And do you understand it?
And I want my strategic partner, okay, to be objective in his discussion. He is ascribing his own opinion, okay, to the judges. I have labored to state that in the exercise of judicial functions, the judges do their work independently, based on the law and evidence. Now, for him, he's saying that when His Excellency expressed his view or feeling about a situation, one, we should agree the president is also entitled to a view. He is also entitled to a feeling. But I want him to appreciate that just as he's ascribing his own feelings, they cannot constitute to be why I am speaking the way I'm speaking. I am speaking because even myself, if I'm doing what I am doing in the exercise of my judicial function, it is not his feelings, the sentiments and those other considerations, it is the law and fact. Now, if the judge listening to an application was not satisfied, he rendered his discretion. He is the one who is interfering with that discretion, yet legal process is available for him if he was dissatisfied
to seek redress.
Sought redress to the next level. You understand it? He is a very wonderful strategic partner. And we want to say, yes, as a strategic partner, let us also be strategic in our arguments. Okay? So that we don't give a wrong impression to the listenership, because the viewership
when you have such
need proper guidance.
Yes. So when you have such a letter, Jude, isn't it ground enough for you to go to court and say such kind of letter should stop? Must you just be complaining?
No. Or maybe hold it. You see, Patrick, yes. These are, when you have threats of this kind, how you respond to them is different. The president is ahead of the most powerful arm of government. Okay, every time he makes a statement complaining about a particular court matter, that court matter gets decided the way he wants it to go. That's the pattern that we see. On bail, you see it on bail, you see it on this matter. Then ultimately, when you have that pattern, like His Worship says, the president has a right as an individual to also complain and if he's not happy with the court decisions. Fair enough. But
so
when you see a situation where his statements continue to have a bearing on how matters get decided, it simply means that the independence of judicial officers is being eroded. we can complain to him that he shouldn't undermine judicial officers. But also we have to send a signal to our judicial officers that they should assert their independence. For instance, I know His Worship issued a statement in January this year about the resident district commissioner of Ntungamo for interfering with the court processes. And for me, when I read the statement, which was a very good statement, I kept thinking, how come they didn't? They have reserved this for a resident district commissioner in Ntungamo and not the president when he has a much more concerning letter that he issued. So, because you see, we need the public to know that the judiciary is independent in its operations, and that independence is something that is so integral to the running of a democracy. Independence of the judiciary is so critical that when you have a series of actions that are eroding it and threatening it, as lawyers, as court users, members of the public, we have to be concerned. And that is why many of us took the view that we now need to help our partners to protect them by sending a message using a different sort of power. Because you see, us when we a boycott, calling for a boycott, it's just that's a tool of the oppressed. We are not powerful. There's nothing more we can do. The judiciary is very happy that the executive has increased their budget. But for us, we are worried that yes, they seem to be the partnership with other arms of government, especially the executive, is beginning to concern us. We are happy that they have the funding they need to serve us. But if the funding is going to compromise their ability to be independent and impartial, we would rather they have less funding but they are independent. Because now it seems it is a...
So, Your Worship, it appears...
It is a give and take.
Freedom to protest and freedom of expression is in the dock.
No, you know, Judy is bringing a very unfortunate scenario.
The bar against the bench.
They are happier we have no funding, because in their view, that is what
you are judicious.
No, we are saying if the funding, if getting excessive funding is going to compromise you, because now you want to listen to the executive more, you'd rather have less.
Are you telling us that internationally, where judiciaries are well funded, that's how they are behaving? No, I want to make this one clear. On Monday, in His Excellency's messages to the judges' conference, he categorically stated that the courts, should be allowed to exercise their functions independently. I do not know why my brother has issues not appreciate that the executive itself is committed to ensuring that there is that independence. The Honorable Chief Justice has said it, that yes, we relate, and we should continue relating as arms of government. We are talking of government, okay? And I wish my brother here appreciates the relationship between arms of government and how they work. And in that working, I want him to understand that that doesn't stop communications between them.
But you know, there's a history of interference. I remember around 2006, during the arrest of Dr. Kizza Besigye, I remember the Daily Monitor called it the Black Mamba when they stormed the court. And the principal judge then called it the rape of the temple of justice. Again, was choosing the executive. There is a history to the interference.
And those were unfortunate acts of a section of forces which was not appropriate.
With no command and control? The forces with no command and control?
No, you see...
Do you know the forces have a commander-in-chief?
We need, but do you have proof that it was actually the commander-in-chief who sent them? Let us understand these things. The Honorable Principal Judge,
that history of interference
they did not...
As recent as 2006?
No. What I'm saying is...
In the broad daylight.
The protest then was for that unfortunate sin that was created by the storming. And that's the protest which was about. He said, no. You don't come and storm into the court. The court is a temple of justice. Come on. You understand that. And I wish people can understand that. And that was stopped. All right? Now, my brother here is saying...
But you know that's the same government that's still in power.
Being the same government doesn't mean that the same practices yesterday should be the same practices today. Things change.
I think you're about to become a government spokesperson. Mr. Mawanda, gentlemen, we're going to take a break, and on the sport we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara, and my guests tonight are James Eremie Mawanda, Public Relations Officer to the Judiciary, and Jude Byamukama, a lawyer, and we're talking about the independence of the judiciary in Uganda. And I think, according to Mr. Byamukama, the independence is being eroded with this interference from the executive. And even when they want to express themselves, they are stopped, as if the freedom of expression seems to be in the dock. This is very interesting when the bar is against the bench. It's not very common. But, you know, so you don't want to participate in tomorrow's, you are boycotting tomorrow's new, is it new
lawyer.
New lawyer. How does that help?
It helps, one, in two regards. First of all, we are sending a signal that we are not happy. We are not happy that the independence of our judiciary is being eroded. We are not happy that as we try to complain about the threats to the independence of the judiciary, we are also being gagged not to talk about our serious concerns, which probably validates our first concern. And therefore, we wanted to create a clear platform for the public to know that all is not well in our house.
Now we're talking about the public. I have the numbers on the screen. You can pick your phone and call us and tell us what you think. Please be precise and concise. And should you disagree with my... Yes, sir. What's your name and where are you calling from? Hello? Okay. Probably I'll still explaining. I have the numbers on the screen. You pick your phone, you call us, and make it very brief. Should you disagree, that's very normal, but remember to disagree with civility and make it as brief as possible. Yes, you're still explaining. As when a call comes in,
so,
then I'll be able to...
What we are saying is, and but this is not the first time that such a boycott takes place. You may remember less than 6 years ago, during the leadership of Ruth Sebatindila as president, when again the head of state had delayed or failed to appoint a substantive chief justice and deputy chief justice. We also agreed as members, our leadership guided us and told us, look, we need to express our displeasure that we don't have a substantive chief justice for over a year. And we expressed our displeasure by boycotting the beginning of the new law year. And it's in the same spirit.
Jude, let me take a call online. I have a call online. Hello.
Hello.
Yes. Good evening, sir. What's your name? Where are you calling from? And give us your submission.
My name is.
Okay. Could you try again? Hello.
Hello.
Yes. Good evening. What's your name? And please give us your submission.
This is Peter Walubili.
Oh, Peter Walubili. Council Peter Walubili.
Yes.
Okay, go right ahead, sir.
Hello?
Go right ahead, sir. I wish you could turn down the volume of your TV so that it doesn't bring an echo. If you can turn down the volume.
Yes, yes. Okay. Now, there are 2 points I want to make.
Okay, sir.
One is that people publicly state positions. The president has said he is not interfering in the independence of the judiciary. The Chief Justice is saying that there is no interference. But the rhetoric has to be matched in practice. In practice, there is abundant interference by the executive in the independence of the judiciary. Very, very many people have court orders that can't be implemented because RDCs, because ministers, because these people in government cannot allow including RDCs, to have those orders implemented. Two, on the specific issue of the meeting that was stopped by the court. Before that meeting, attempts were made and engagement made to the executive of the Law Society to convene a meeting. When the executive of the Law Society refused to convene the meeting, that's why 15 members petitioned for that meeting. So when a member sues the executive of the Law Society, which had itself failed to convene the meeting, and the petitioners are not involved in defending their meeting, you see a conspiracy between the court and the executive of the Law Society to subvert the intentions of convening the meeting. Why would a court of law not want to be its independence to be debated and defended by the bar? Clearly, we are sweeping a lot of dirt in the carpet. I respect His Worship Eremie, but I can see he's trying to do his job as a PR, but we have a problem. We have a problem. Judges are suffering quietly. They have to look over their shoulders before they write sensitive judgments. The files are being called from individual judges to their supervisors in the course of hearings. And clearly, anybody who says that there is a functioning and independent judiciary in this country is hiding his head under the sand.
Okay. All right. Counsel Peter Walubiri, first of all, we are very honored that you follow this and you are able even to make time to be able to give us your submission. Of course, His Worship will be able to respond to you. Let me try to maybe take one or two more callers so that my guests can respond. I have a call online. Hello.
Hello.
Yes, good evening, sir. What's your name? Hello? Okay. I will always tell you that if you are making that call, please you turn down the volume of your TV so it doesn't send an echo to you or to us. That's when we can have a healthy conversation. But if your volume is high on the TV when you're watching, then we cannot be able to have a conversation. Hello?
Hello?
Yes, hello? Okay. You've done the same thing I've been trying to explain. That you turn down the volume of your TV, then you can make a call. Or maybe you walk away. But if you are standing close to your TV and then you call, it will send an echo. We will not be able to listen to each other. Hello? Hello?
Hello?
Yes, good evening. What's your name? Yes, sir. I can hear you. Good evening.
Hello?
You're on air. What's your name?
Hello, Canada?
Yes, I can hear you. Go right ahead, sir.
Yes, this is Professor Christoph from the School of Law, Makerere.
Bazira School of Law.
Good evening to my colleagues there, Eremie, and my very good friend Jude. A very interesting conversation. I'm actually doing research on the judiciary and writing a book on the same. And one of the areas I'm looking at is the independence of the judiciary. When you look at it historically, the judiciary has always been a victim of interference with its independence. This is something that has happened consistently. But what is most interesting is how the judiciary itself has responded. Historically, the judiciary has responded, but not in a very consistent manner to defend its independence. Sometimes it's just an individual judge coming out like Justice Ogola did, and maybe a few judges joining in. But the most interesting thing is that we've now moved into a new phase, and a very worrying one, where actually the judiciary is now fighting those who fight to defend its independence. I think that's a worrying stage that we have.
That's why I was telling His Worship that Jude is a strategic ally. He should be happy.
Yeah, sure. So it's really shocking.
Please continue, Professor Bazira.
Yeah, and surely it's so shocking, and just as Senior Counsel has said, that the bench comes out to gag a bar that is actually fighting for its independence. It's a very worrying trend, and I tend to agree with Jude. If the problem is the budget, then I think it's a very, very big problem. I know that the judiciary is right now grateful to the government for having increased its budget tremendously. Yes, it should be grateful, but that's an obligation of the state. It's not like the judiciary must now bend over simply because it has the budget has always aspired to have. It still needs to defend its independence. And you contrast what is happening in Uganda and what is happening in Kenya.
Mbazira, I have a question for you, Professor Mbazira. Every time there seems to be interference from the executive, do you find the judges in Uganda yielding to that interference?
Most of the time they do, sometimes in a subtle manner, sometimes in a subtle manner. But what we want to see is that the judiciary itself should come out strongly and actually defend its independence. And it should give room to whoever comes out to actually defend its independence. So I think if you contrast what is happening in Uganda and what is happening in Kenya, you can see how the Kenyan judiciary has come out, guns blazing, to defend its independence. The Chief Justice has been on record several times to say, no, as executive, you cannot interfere with our independence. You can see, and this has happened not only during the current Ruto regime, but even during the Uhuru regime, the judiciary came out strongly to defend its independence. If you remember how the Uhuru government wanted to cut down the budget of the judiciary simply because it had annulled the presidential election, but the judiciary stood firm, and indeed the executive had to yield. So there are some lessons that the judiciary in Uganda should learn from the judiciary in Kenya. The judiciary in Uganda should allow the bar actually support it and fight for its independence. Thank you so much, Kamara.
Thank you, Professor Mbazira, Makerere University. Thank you so much. He's even doing a research on the issue of the independence of the judiciary in Uganda. Yeah. It's an honor to have a call from Professor Mbazira, and even before that, to have a call from the Senior Counsel, Walubidi. Let me try to take Hello, good evening, sir.
Good evening, Patrick. How are you today?
I'm fine, thank you. What's your name and where are you calling from? Please go for it.
This is Byron. I'm calling from Makinge here.
Byron. Okay, Byron, go right ahead, sir.
My concern to the judges, the land people there, like they always say, and I believe they do, I would like to know at what stage do they think about national interests outside the law? Like we had this recent Justice 17 do her judgment. Because I don't believe her judgment was only based on the legal principles. It had some other factors, other variables outside the law. So in our Ugandan setup, where do we have things that are outside the law but influencing the judge that makes the judgment fair to the nation, to the economy?
I hope you know the example you're using of Justice Julia 17, that her own peers have actually elected her to be their leader, deputy.
Exactly. Because we need to tell these judges and lawyers that not everything has to be sorted based on only and only legal principles and legal variables. Okay. So at what stage do we have that other variables outside the law take part in these
variables outside the law? That's interesting. I would want to hear whether those are also considered. Okay, I understand there are quite a number of you who would want to give your views or ask. I'm going to take the very last so that my guests can conclude by responding to your questions or comments. I have a call online. Hello. Hello. Okay. So I suppose you've listened to all these, and Your Worship, you have so many to respond to. If you can go for them.
No, thank you very much, Mr. Kamara. And I want to thank my good friend, Senior Counsel Peter Walubiri. And I also want to thank Professor Mbazira for those comments. One thing I want everybody to understand is that we are not refusing strategic partnerships with the Uganda Law Society in the quest for the fight for the independence of the judiciary. We are not refusing that fact, okay? We are here today to distinguish the quest for supporting the judiciary fighting for independence and the mix up because a matter went to court and a court exercised the very independence to take a decision on it. And that's the issue, and that's the demarcation I want us to appreciate. From when we started this talking here, you have understood that my brother Jude's grievance, he is the, first of all, is the complainant, and he wants to be the judge. You understand that? In this discussion. A matter went to court, decisions were rendered, they are even appealable, but he is refusing to respect the decisions of the court. Okay? And he is complaining. And yet we are saying, you know, that is not the end in itself. If a first decision was rendered, the Law Society has exercised its
It's not
right.
agreeing with this decision, but he respects it, I think.
Let him respect it.
He's just not agreeing with it.
He's not agreeing it.
Which is also okay.
And which is okay. And they have even taken a very positive step to appeal the decision. Okay? And that alone, okay, should call for them to respect that due process. All right? And I want them to appreciate that this is the first reason why they should appreciate and understand that independence begins with us, the players. The Law Society appreciating that decision is the decision which was rendered until the appellate court will do what? Will turn it. Probably in their favor. And so they will now say, now the courts are independent because probably. And I would be happy if something of any sort like that comes up. Because we know very well in Uganda, anyone who has lost what they want in a court, they will have reason to complain. Uganda Law Society, the legal fraternity outside the judiciary are our strategic partnership. World over, we have cries over interferences with the judiciary. And world over, the quest for ensuring independent judiciaries is the discussion, is the conversation. And we cannot be here to say that we are disregarding that support. We need it. But we don't want it to come out of context. Boycotting our Law Society, as I heard lastly here, is shooting ourselves into the foot. The other one was a court case. But here we are partners, stakeholders coming together to celebrate a new lawyer. What does that got to do with independence? Yes, they are expressing dissatisfaction. We are telling them, yes, you are very positive to express dissatisfaction, but it would be much better. And I love the submission of the president when he said, no, we shall be there. And I want to call upon the fraternity, let them come. Okay? And probably in that discourse, we are able even to appreciate better. We need a lot of these conversations amongst ourselves than shooting ourselves into... You know,
there was a comment, I think, by Peter Walibiri that the rhetoric of the president is matching the practice.
I want to respect Senior Counsel Peter Walibiri's opinion, and he's entitled to his opinion, but by and large, we want his very good support to ensuring that, yes, our judiciaries can exercise their functions without interferences.
And Professor Mbazira
is even writing a book.
Yeah,
and we shall be happy to receive his findings.
He's telling you he has already seen the interference.
Of course, when you write a book, you are expressing your views. Some may be supported by findings, but we shall be happy to receive that very good discussion from him. And Mr. Byron was wondering whether when we are doing our work, we only look at the law. I want to assure Mr. Byron that it's not only the law. We look at the law, we look at the aspirations of the people, we look at the norms, specifically there is even good conscience, there is public policy issues, so many considerations. Some are even codified within our law, others are international norms, etc. Because he also alluded to the case
and the International Court of Justice,
the ICJ. So there are many considerations in addition to the law. In addition to the law. So by and large, I want our brothers in the Law Society to understand that we are not refusing their support for the fight for the independence of the judiciary. In fact, they are our strategic partnerships. But we should do it in the proper context.
Okay.
Not again to be ourselves who are showing the public that we are disregarding.
Let me have Jude also respond. Well, there were not questions to you, but what do you make of these submissions?
Maybe starting with the last one of Byron, this whole idea about national interests vis-a-vis the law and what other variables can exist apart from the law that maybe courts should take into account. By the way, that is that is also alluded to in the famous letter of the president, because I think he sort of claims and says, well, if the law is not there to protect some of these monuments, there is common sense and logic. But I think what we need to understand is that the job that judicial officers are entrusted with is to interpret and apply the law. The job which the executive and parliament are entrusted with is to deal with those other variables apart from the law. The job of parliament, the job of the executive is to discuss what are these other variables that can help us have a better society, a better governed society, a prosperous society. Those variables are then reduced into policies. And then those policies influence the enactment of laws. And now the job of the judiciary is to ensure that the executive and parliament are following the laws that have been enacted, and to ensure that the public is benefiting from whatever rights are created by those laws, or to ensure that even us members of the public are held accountable under those laws. So it is always a dangerous thing to try to encourage judicial officers to think about other considerations other than the law when they have to make their decisions. That's extremely dangerous, because that is a job of politicians. It's not a job of judicial officers.
Okay.
Now, obviously, Professor Mbazira and the Senior Counsel Peter Warubili do recognize what I'm saying, and they have been around much longer than myself. And these are people with over 25 years standing. And you see, they can see that we are in a very worrying situation. This is not just a simple, there are people out there trying to paint it as a simple knee-jerk reaction to a particular situation. It is not. What for us we have seen throughout the course of last year and the previous year is a consistent pattern of eroding independence of the judiciary. And we are saying, no, it's time to put our foot down and say there is a big problem. One, by not turning up tomorrow, we want our partners to know that, oh, there is a problem. We would like them to know there is a problem. The issue is way beyond this idea of the order gagging us not to meet and discuss that problem. But the signal is there is a problem. We want to know. And we want to know why individual judicial officers should receive directives to change decisions they have already made. That's contrary to the law. We think that's a big problem.
Okay.
We want to know why when the directives come from the executive or outside the judiciary, or even within the judiciary, some court cases are given priority, and then some other court cases are never had at all. There are parties complaining, for example, who are challenging that whole car tracking, the vehicle tracking system that was being put in place. They have been complaining. They want, some of them were actually sending me messages that, you see, for us, we applied for an interim order. We have never even been allowed to be heard. We can't be heard. But others filed cases on Monday and they are heard on Tuesday. So you see, all those are perceptions. Sometimes perceptions may arise out of maybe a misunderstanding of how the judiciary works. But you see, as we are partners in the system, we understand the ecosystem. We don't just wake up and complain. We go to court, the judges, the magistrates, the registrars, sometimes they rule in our favor, sometimes they rule against us. Uganda Law Society has lost some matters in the Constitutional Court, has won some others. It's a normal thing, it's a normal thing. But what we are looking at now is a very extraordinary situation where we are being told, no, you are not supposed to actually meet and discuss concerns that you see, first of all. And then secondly, we have these concerns, but we are being told, no, don't worry, these are not big problems. But there are problems because so many of us, when we have a judiciary that in which the public does not have sufficient trust, it affects all of us.
Okay.
And what we are trying to do, is send an important message that there is a problem, and we do not want our judicial officers to look at beautiful new buildings, enhanced pay, which is of course very good and important, a large budget, and forget that you see the fundamental reason why they are there. Is to check. The other arms.
He's concluding. In the interest of time, what is going to be your parting shot? Then I come to you.
Okay. In terms of my parting shot, independence of the judiciary is very important if we are to have a fair and just society. And we are, us who are practitioners who believe in the practice of law, us who are avid supporters of the rule of law as opposed to the rule by law, we strongly believe that there are significant actions that have happened in the past several months to give us a cause for concern. We see individual judicial officers having their independence interfered with by their superiors and supervisors. We see courts of law being interfered with by the executive. When we see letters being written like what we have spoken about and others, we get worried. We get worried. When we see the president making a statement that he's opposed to the idea of granting bail to people, to murderers, and then a few weeks later, members of parliament are denied bail, it causes us to worry. It causes us to worry, and we think the judiciary, the members of the judiciary, whom we respect, whom we think can and should aspire to be fair-minded judicial officers, should also agree with us that there is a problem that needs to be solved. And that problem cannot be solved by us pretending that the status quo is comfortable, and we should not try to disrupt it in any way.
All right, thank you very much. And James, your parting shot?
Yeah, thank you. That before I give the parting shots, I wanted to ask my brother to look at Article 126, one of the Constitution. It is the exercise of judicial power, and it is couched in very clear terms that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the law. And that's what he is ending at. But further says, and with the values, these are the considerations.
Other variables. Norms
is a variable.
Politics
and the aspirations of the people. He is choosing deliberately to ignore the other variables, and it is within the Constitution, which he, I know, cherishes to quote at all many times. But I wanted to clarify so that our viewership can be properly guided that yes, it is in conformity with the law, values, norms and aspirations, and these are very pregnant statements. Number two, I want my brother Jude and all the fraternity to appreciate that we are partners in the quest for the independence of the judiciary, and it's a continuous conversation which we would like to be together, and we continue developing until we reach that successful position. Okay, and we are not pretending that we are at it. We want the support of the Uganda Law Society and all the other legal society. We are calling them, let them come, and we continue with this conversation. It is these engagements like the Law Society, like the new lawyer tomorrow, that brings further cohesions between us, and we talk one-on-one. That's the wonderful conversation we can have one-on-one.
All right.
It's a face-to-face. All support we get from the other arms of government and all the commitment which will ensure the independence of the judiciary for the service of the people is most welcome. And we are asking them to respect the decisions of the court. If they are dissatisfied with the decisions of the court as parties to matters before courts, the legal process available should be used.
All right, gentlemen, Your Worship, James Eremi Mawanda, I want to thank you so much for the time you've given us and for the value you've added to this platform. Counsel Jude Byamukama, I want to thank you so much for the time you've given us, and also you have also added value. I can understand that the bar against the bench is a normal kind of situation, I suppose, and also it tells us the healthy of the judicial system, that you may not agree with each other, but isn't that always the case? But you have to respect each other. You may not agree with each other, but I suppose you'll have to respect each other. And I want to thank you, all of you, the viewers, for the time you've given us, for the company you've given us, and those who have called in. So we're so grateful. And this brings us to the end of tonight's edition of On the Spot. Good night and God bless Uganda.
Thank you.